I'm Martha Karua, SC for Morara Kebaso, together with Honorable Eugene Wamago, Honorable Jeremiah Kioni, Asha Bashir, Ndegwa Njiru.
Just the open council, you don't know first.
Oh, sorry, I forgot that we are taking my name. Swati, Asha Bashir, Jam Maina, Ndegwa Njiru.
I'm present, Your Honor.
Eric Deuri.
Your Honor.
There are more. There's Gishohe Dungu,
Present, Your Honor.
Gitahi Quincy. Gitahi is not present. Who else is present and I have not introduced?
Yes, Origi Waswa.
Patrick. Patrick Rawanyama. Omboko Charles. Kyoko Mwende.
Present.
Anybody else have left out?
Unaitwa nani?
Maybe. Thank you.
Which language do you prefer?
English.
Your Honor, on behalf of the prosecution,
and the person who is buying the property is William Ruto. To make it worse, William Ruto has used his powers to undervalue the property, to buy them at a cheaper price. That is the kind of a person we are dealing with. He has no friend. Contact whose information you knew to be false and calculated to tarnish and discredit the reputation of one David Langat. Is it true or not true?
Before he pleads, it looks like there is a mismatch in the charge sheet, and that it may not be worthy of pleading to this. I will be asking you to reject it under 89. If you look at the charge sheet and the particulars, if at all any name was to be tarnished, probably it would be that of William Ruto, if the particulars were not true. It would not be the name of David Lagat. So what is the fear of putting the name of William Ruto as the complainant? This is a very, and you can see, I don't know how it has been drafted, but if there was a name to be tarnished here, the person who is looking like ungrateful and not quite a friend would be William Ruto. So I'm urging the court to read the charge carefully and reject it. Putting up on this charge sheet. Even if we go to trial on this, and even if David Lagat comes, it will not be sufficient without William Ruto as the complainant.
Yes, Your Honor. Just to be fair. Yes, just to be clear on what the senior counsel submitted on, there is no doubt that the particulars of a charge sheet must be able to inform the accused person what he or she is pleading to. And that the particulars must speak to the alleged offense. They must clearly square out the subject of the complaint to which our client has been brought to you to plead is one Mr. William Ruto. And therefore, if the offense as drafted was to have any meaning in law, to the extent that our client is able to respond either positively or negatively, the particulars must relate to the subject. To that extent, Your Honor, this charge sheet is defective, written on, and our client is not able to plead it as the particulars do not inform on how he should plead. It does not disclose who is the complainant. Is the complainant Mr. William Ruto, or is it D.L. Langat? And this is so important, Your Honor, and fundamentally important under Article 50, in the sense that we shall be requiring the statements of the complainant at the trial or at the fullness of time. So if a charge sheet is jumbled up as it is, Your Honor, it's only causing embarrassment to our client, and to this court. That's all, Your Honor.
Your Honor, the charge sheet brought before you this afternoon, Asha Bashir.
And so that we don't take a lot of time on this.
Yes, I'm only raising one
Just a
issue.
request that you do not repeat what the other things
Yes,
were
yes.
already.
I'm only raising one issue, that the alleged complainant here is also not a witness. I am wondering how the two police officers will be the witnesses in this matter, yet the complainant is not. So I humbly submit, like my seniors before me, that this is a faulty charge sheet and should not see the light of the day. Thank you, Your Honor.
Your Honor, I'll make a very short statement.
Yes, Your Honor.
I'm Willis Otieno. Judges proposed against him sufficient detail. What is presented as a charge sheet, if you look at the count 1, it talks of cyber harassment. But look at the particulars. That is where the devil lies. And where the devil lies, it sets out a purported ex post, but proceeds to show you where he's sleeping. Content whose information you knew to be false and calculated to tarnish and discredit the reputation of one David Lagat. This speaks, Your Honor, to a question of reputation, not harassment. And if it is reputation, it's defamation. If David Lagat or William Ruto thinks that this post has injured their reputation in the eyes of right-thinking members of the society, their recourse is in the civil court. They sue for defamation. And criminal defamation is no longer applicable in our legal system. So that if the particulars presented before you to be set free forthwith, unless otherwise lawfully detained. So this is prejudicial at the outset. That's all.
That's the challenge with us lawyers. We respond even to what we don't know. We don't know what I was going to say. So I've been writing manually. Have been set up. I will now not be writing. But please, when you speak, say your name at the beginning and use a microphone. Yes. So we'll have them transcripted.
You know, I'll pick it up from where my learned senior Mr. Otieno left it, and urges to go straight to Article 25 of the Constitution on rights that cannot be limited, Your Honor. One of the rights that cannot be limited, and while all other rights can be limited, is the right to fair trial. You know, that is under Article 25C of the Constitution. Very quickly, Your Honor, I'll, with humility, invite the court to read that together with the provisions of Article 52B, which my learned senior, where my learned senior left. 52B, Your Honor, is about the right of the accused person to be informed of the charge with sufficient detail to answer it. Your Honor, what has come out in the few minutes before,
Your Honor, 50 sub-article.
50 sub-article 2B. If I'm not wrong. Your Honor, it talks about what fair trial, all that is under Article 52, from 2A all through to 2, I believe, J. 52A all through to 50Q, Your Honor, is what constitutes fair trial.
Your Honor, I'll finally say that, and I think I have said this before, if we continue at this rate, we will have to seriously expand this course. Because, Your Honor, what it would mean is that any statement that a person can make under the free speech that is guaranteed in this country sometimes, yes, I can say something that can be offensive. But does that constitute a crime? It's the danger that we face with this kind of charges that have been undertaken. And the attempt to sanctify, Your Honor, those actions does not meet what is contained in our laws in terms of the kind of charges that should be presented and accepted before the court. Your Honor, this court must remain what it is supposed to be. But they must be a place where they know that they can play their little games outside there with the lives of each and every one of us, because it basically means that no one is safe. I can make a statement that it is deemed criminal. Let them know that those games will not be entertained within the corridors of justice. And so, Your Honor, I plead with this court that we must take all the circumstances of this case and the circumstances of this case, then explain the paucity in the charge sheet as has been presented before them.
Your Honor, maybe I have an emergency at the back here. It's the order of the court. Directly for this.
Somebody has a seizure. Maybe call for a shot.
Thank you. Your Honor, it is to be a condemned. We abduct or we arrest without any probable cause. We look for any reason and we present a charge sheet and place it before the court. And the court then is supposed to be the one to sanctify, because, Your Honor, the moment you accept this charge, and I think if it was a proper charge, we would have no problem, even though we would have known it is prohibited. But the problem here is that, Your Honor, if you accept this charge sheet, especially as it is framed.
How many more minutes will you take?
3-4 minutes.
Okay.
That's too much. Your Honor, in brief, what we are witnessing here as a country is the weaponization of the criminal judicial process against a young man who, against all odds, stood up to speak the truth. And the truth has hurt many people who are currently in power. That truth has altered the status quo.
Sorry, you're not a witness. You are yet to take plea. Please.
But in brief, Your Honor, history is being made, and I invite this honorable court to stand on the right side of history by quashing these charges and releasing the accused person on personal one. He is a young person, he is a young party. To release, to free him completely, free him of this charge. And lastly, as his personal lawyer, I want to thank him for actually believing in a young person. Fellow Gen Z, Your Honor. Fellow Gen Z. And we will stand with him.
Additional justification for the cause of action we are requesting you to take. If you look at Article 24, there's a balancing act that the court must strike. and the court must look at the least restrictive alternative. In this case, Your Honor, there is an alternative for the complainant. That alternative is called the Defamation Act. It's sufficient to address any reputational damages. And so there will be justice for the complainant, whichever, if you make the decision your request is to make. And the other one is in Article 23A. That article obligates this court to adopt
Article
20 Subarticle 3A. You know, this court cannot interpret the Constitution that jurisdiction belongs to the High Court. However, this court, as a constitutional organ, must apply the Constitution. And when you look at Article 23, it requires this court and all tribunals to adopt the interpretation that most favors the enjoyment of rights. In this case, Morara's right to freedom of speech, especially on the issues he's speaking about. So, Your Honor, there's sufficient rationale in the Constitution, sufficient legal basis for you to find that this child does not disclose a criminal case, and that the remedy, alternative remedy of defamation is sufficient. Thank you so much.
Your Honor, perhaps before the prosecution responds, when our client was arrested, they say that they arrested him today. And the fact is that they arrested him yesterday. They have a duty to disclose all the material facts. And there is a reason why the CPC requires a date of arrest to be indicated on a charge sheet. Eventually, Your Honor, when you sit to retire, kindly order the DCI office, and this is the DCI himself, to release 3 phones and 1 laptop belonging to our client forthwith as you discharge him. Most obliged.
And has been produced in court within the required time limit.
Your name for the record?
Undimu. And has been produced in court within the required time limit. In terms of access to counsel, I did confirm with the officers that he was allowed access to counsel, and the counsel who was allowed was Mr. Ndegwa Njiru. And in fact, Mr. Ndegwa Njiru did appear at our office today morning. And we confirmed that the charge sheet will be dropped. He was accompanied by 2 other counsels, though they declined my tea invitation. Your Honor, in terms of the charge sheet, the CPC is very clear that the charge has sufficiently informed the accused person of the accusation against him, which in our humble view are sufficient to enable him respond to the charges. To delve into other issues, Your Honor, would be going to the merits and demerits of the particular matter. I do understand the constitutional issue that have been raised by my senior colleagues. And those issues cannot be raised as at this point. The only purpose we are here for today is purposes of the charge sheet, whether it has statement of the offense and the particulars of the offense, and other considerations. Refer this court to section 137 of the CPC. Your Honor, the last point that Mr. Ndegwa has raised on the issue of to find out if they are interested in the material or the same should be released to the accused person, and undertake to inform him before the closure of business today as to what the response of the investigating officer has been. Luckily, I have Mr. Ndegwa's number. And also Mr. Eric Teuri. Surprisingly, the squatter from Tuapa has not spoken. I'm sure he will respond.
Vice President, I may put a rejoinder at the end as you make the decision. No, I think so.
With one sentence to the DPP.
So the prosecution is done?
Yes.
Yes.
Just to remind the court that our plea is that the charge be dismissed or rejected as defective under 89.5 of the CPC. Our submissions by the various councils point to that direction in adequate words. And it is important that the court only invites the accused to plead to a charge that discloses the course of action. And we have shown the mismatch between the offense charged and the particulars. I need not go beyond that. But when you retire to make a ruling, should you require more time, we urge you to consider releasing Mr. Morara, who is, I'm informed, is an officer of this court, on a personal bond. He is, I'm informed he's not an officer of the court, but he is a person who is well known, has a fixed abode in town, and he is not a flight risk. You may consider releasing him on a personal bond, because we must not encourage the behavior of the police of punishing people in advance of appearing before the court. By punishing, I mean detention, unnecessary detention. He is a person who can actually be released on free bond. And we are many, and we will make sure he appears.
That should bring it to a close. The best way to do that is to reserve the ruling. For what terms would you consider appropriate?
He is a businessman, and he is a very well-known, active, and engaged citizen. And he's also a lawyer waiting to be admitted. I actually thought he was already admitted. That's why I was saying officer of the court.
So you can afford a cash bail of 1 million.
Otherwise,
how much cash bail is he able to afford?
10,000 councils will pay. Yeah.
I want us to skip tomorrow. You come on 3rd of October. Sorry, no, 3rd of October. You come tomorrow at 2 p.m. tomorrow. Delivered on 4th of October this year at 2 p.m. Then is granted cash bail of Kenya shillings 50,000 with one contact person to appear before the court on 4th of October this year.
Your Honor, may I just take this opportunity on behalf of all the advocates to thank the court for the indulgence of course, I must recognize that my good friend, Mr. Ondimu, although he sneaked into town and has not yet performed the usual rituals for us to welcome him into Nairobi,